Hello, everyone. Hello and welcome to today's webinar. We still have quite a few people joining. I am just going to quickly start with putting on my camera so that you can just put a face to the name. Hello, everyone. Welcome. It's so nice to have you with us today. Please note the webinar is recording just for the sake of transparency. We will be recording the session and making it available afterwards to everyone who registered. We have quite a lot of registrations for this morning, so thank you to everyone who's joining us. We're very excited for this topic with you today. So before we get to the actual presentation, while we are just giving a few minutes for everyone to join, I'm just going to share my screen. And then what I'd like to do is to just ask you to have a look at the screen and share with us, just as an icebreaker. Today's topic is all about IR trends, traps, and transformation. So we would like to hear from you. What are some of your biggest IR struggles? So you'll see on my screen, it's a Mentimeter that we're using just for this poll. What you can do is to scan the QR code on your phone. It will allow you then to open a browser link and type your response. Your responses are recorded on the screen in the form of a word cloud. It won't be associated with your name. It will just have the response there. And then, or you can alternatively go to menti.com there at the very top of the screen and use the code displayed at the top to sign in and record your response. So please share with us, what are some of your biggest IR struggles? So not only maybe for your company, perhaps you are joining us as a consultant today. Absenteeism, we see, is the first response there. You can type up to 3 responses. You can even submit multiple responses. We want to hear from you. What are some of your biggest IR struggles, either the experiences at your company or for you as an individual, perhaps being the consultant that is called upon to actually deal with these cases? Chantal, our presenter for today, we're going to introduce her in just a moment. Chantal, we have quite a lot of responses coming up on the screen. It seems like IR can be quite challenging for all of us on the call here. I'm sure it can be a very complex field. We have misconduct, we have harassment, absenteeism, complex procedures, remote working. So remote working for all of us on the teams today. Not working all hours. Sure. Okay. Poor performance, poor fit. Chantal, change resistance. Is these some cases, things that you're regularly seeing with your other clients as well? Does it look familiar to you?
Yes, loophole. I like that one.
Which one? Loopholes.
Loopholes.
Yeah.
Yes,
No,
high absenteeism. That is, I think, yes, absenteeism, poor work performance, definitely. Misconduct in general. Harassment is quite a surprise to me. I haven't seen a lot of them lately.
Yeah. Unique industry. So perhaps being in an industry that has a lot of unique challenges to it that maybe is not so sort of common across any industry, but maybe specific to specific industries. Inconsistent managers.
Oh,
That's
yes.
probably also something you've seen a lot of. Unions. I'm sure that's also quite a big one. Hey, unions. Non-adherence to legislation.
100%.
I can see how that would also create a lot of problems and frustration. Let's have a look. Poor fit. That's an interesting one.
I like the abuse of disciplinary procedures.
Yes.
I can see where that comes in as well. Manager skills.
Yes. I'll just give 1 or 2 more minutes for anyone who wants to maybe add a response. Miscommunication.
Yes.
Miscommunication.
Yes, very
Yeah.
common. Very common.
Yeah. And we're probably laughing not because we find it funny, but because it's interesting to see how perhaps, you know, a lot of us feel like we are seeing kind of the same sort of challenge in the workplace, and it's just, you know, it's so relatable. I think a lot of these challenges that we have recorded on here, very relatable.
Very, very. I
Okay.
like the workplace conflicts. That's also very common.
Yes, 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 yes. Yeah, and if you are the person charged to deal with these issues, can you imagine that that can be very challenging and complex at times, I think, to deal with. So yeah, we have quite a lot of movement on here, quite a lot of responses. Personal issues, that one I think
Negligence.
would probably, yeah, favoritism, substance abuse, Chantal. We have some
Sure.
serious cases on here, some serious cases on here.
Mm.
So, yeah, thanks so much everyone for sharing. I think it looks like today's topic is quite an engaging one. We're very excited for that. I think let's get going with our presentation. I'm going to stop sharing for now, but thank you so much for taking part in that little icebreaker we have. I think it gives Chantal, as the facilitator or presenter today, also a very good idea of you know, some of the kind of in your context, the challenges that you are dealing with, and gives an idea of the biggest struggles that you are facing in your company, or perhaps even as a consultant or practitioner charged in dealing with these cases. So just to quickly introduce myself, my name is Helena Nell. I'm a senior HR consultant at P&H Solutions. Some of you might have been on our previous webinars. We actually have a quarterly HR webinar. Today, of course, focusing on the topic of IR, trends, traps, and transformation. We have Chantal joining us today. I'll introduce her and give you her overview or bio, so to say, a bit later. But thank you so much, Chantal, for joining us. We're very excited for your presentation for today. I think a lot of relatable topics that form part of your presentation. And then, yes, of course, welcome to everyone joining us today, as well as the rest of our P&H family supporting us today. Thank you for joining. So yeah, today we're going to chat all about IR. Just some quick housekeeping. If you have questions throughout the chat, we're going to have Chantal present her slides, but you are more than welcome to pop your questions in the chat. We also have a Q&A at the end of the session that we have provisioned for. But as you perhaps think of things or would like to perhaps leave a comment or leave a question, you are welcome to use the chat functionality as we go through the presentation. And as I mentioned, we will be sharing the recording with you afterwards as well. So I think let us go on to the next slide. Thank you so much for sharing the slide, Chantal. I can perhaps then go to Annemien. I want to introduce her as well. Annemien joining us as well today from the P&H team. Annemien is our service delivery coordinator. So Annemien is the person at our company that makes sure everything happens. And she does an excellent job of that. And it's very enjoyable working with her. So Annemien, can you maybe just, for those joining us on the call today, just give a quick overview of P&H Solutions as a company, who we are, just so that for those maybe joining us in future, just know who we are and what we do.
Thank you, Lena. Good afternoon, everybody. And as Elena said, very warm welcome to everybody in the third webinar of our series that is presented on a quarterly basis. It's absolutely wonderful to see so many people joining us today. So thank you for your time, to be here. I know it takes a lot out of your diaries, but it is really awesome to see you guys. My name is Annemien Victor. As Elena said, I'm one of the directors at P&H Solutions, and we are joined today by our managing director as well, Quentin Whittle, as well as Chantal and Elena then, and some of the consultants from P&H. As Elena said, we are a very proud Sage partner, a platinum partner of Sage, which there isn't we only a few Sage platinum partners. We specialize in payroll and HR implementations on any of the Sage payroll and HR products. We do ongoing maintenance support, system maintenance, any system support that you would need, as well as integrations to streamline all your processes. In addition to the system solutions that we offer, we also offer payroll and HR outsourcing, as well as expert support in areas such as performance management, design of it, and the rollout of it. Change management, a huge thing that we do at the moment, which especially when you introduce new trends in the market or new systems or new performance management systems, it needs to be accompanied by change management. And Elena is your go-to person for that. We do organizational development, IR, and much, much more than that. So we really hope that you're going to find today's sessions insightful and valuable. And with that, I'm pleased to hand back to Elena and the team.
Thank you so much, Annemien. Chantal, if you can please open the next slide for us. So I just wanted to go to Chantal and give you a bit of overview and background of her today, also just as our presenter for this topic. So Chantal, she's well-versed. She has a very in-depth knowledge of employment legislations and regulations, dispute resolutions, creating fair and compliant workplace policies, and her comprehensive understanding of labor dynamics positions her as a valuable asset to businesses looking to navigate complex legal landscapes surrounding employment. Something you maybe didn't know about Chantal is she is an admitted attorney, but she has a passion for labor law, and she has over 8 years of experience as an industrial relations specialist. Her key focus is for clients to understand the importance of a proactive approach in dealing with labor law compliance to really safeguard businesses against risks. And on a more personal level, it's so nice working with you, Chantal, and I'm very excited for today's session with you. So I think I won't take any more of your time, Chantal. Thank you. Over to you.
Perfect. Thank you very much. Thanks for the nice introduction, Elena. Thanks for everyone for joining today and for giving us some of your precious minutes during the day. Guys, I just do apologize if I do have a cough every now and then. I'm just getting over flu. Winter is definitely not my friend this year. But anyway, so thank you so much for joining. The purpose of today's webinar is just to give you some information. Like Elena said, we are looking at some trends, traps, and transformations. So under trend, we were going to be looking at three points, some changes to the legislation that's coming, the drafted code of good practice on dismissals, some recent case law that I found very interesting, and I actually like to see that it is also relevant to your business based on our Mentimeter. Very excited to look at that. Some of the traps, what employers should know, and of course, lastly, how we can help. During the session, if you have any questions, please don't hesitate to pop them in the chat so that we can address them afterwards. And if you guys would like more in-detailed discussions, please also contact us after the session so that we can go into more details. So if we then move forward, I know it's been a big talking point during the last few months. It is the proposed changes to the legislation. So guys, none of these changes have been implemented and we are not close to implementation yet. So no need for us to jump currently on these changes, but it's just good for us to know what might be coming. So the NEDLAC report was submitted to the Minister of Employment, who is looking at the proposals now. So those proposals to four proposed amendment bills have been submitted. So the Labor Relations Act is the one with most changes, with 47 changes. Basic Conditions of Employment Act, 13 amendments. 2 amendments to the National Minimum Wage Act, and then 3 to the Employment Equity Act. So as you can see, there's quite a hefty amount of amendments. And unfortunately, we won't be able to look into all of them today, but we will be looking into some of the main ones which we have highlighted. It's not even all of them that we can discuss as main changes, but I think it's the most relevant that we need to be on the lookout for. So if we look at the summary, so if we look at number 1, high earning employees. So the proposed amendment is to minimize the effect and the, sorry, I just need to move my block here out of the way. It's blocking my view. There we go. Sorry about that. So the main purpose of this amendment is to limit remedies available. And the reason for that is due to high earners, when they are dismissed, reinstating them with back pay can be a huge financial implication. So the proposed amendment is that reinstatement will only be available for automatically unfair dismissals. Compensation will be capped at an undisclosed amount at this stage. The cap will not be applicable where cases involve whistleblowing or, once again, automatically unfair dismissals. And the proposed threshold will be set at 1.8 million rand per annum. So if you earn over 1.8 million rand per annum, reinstatement might not be an option for you. The second proposed amendment relates to a test for procedural fairness. And it's interesting to see that this is one of the things that actually popped up during our Mentimeter. So it is proposed to include a specific test for procedural fairness based on the Audi Uitlam-Partlam rule, which once again just means that both parties must be able to state their case. The employee must be given a fair and reasonable opportunity to respond to allegations before being dismissed. So currently, as we know, when we go to the CCMA, we have 2 legs that we need to prove. One is substantial fairness, and the second one is procedural fairness. So the element has always been there, but now we want to put a test in place. And I think this will definitely benefit both employers and employees to know exactly what is expected. It is also very interesting to note that this test of procedural fairness is also mentioned in the proposed code of good practice, which we will be looking after these main changes. So it's interesting to see that we are moving towards a positive change for employers in this regard as well. So sorry, guys. So the third change that is being proposed is a probation period for protection against unfair dismissal. So the new section 188, subsection 4 of the LRA will now introduce a qualifying period for protection against unfair dismissal. What this means is that new employees will not be covered by unfair dismissal protection during the first 3 months of employment, or longer if the probation period is extended for reasonable and operational justifiable reasons. So the purpose and the thinking behind this is to encourage employers to hire young and inexperienced workers for flexibility. So we need to understand from the thinking logics, in my perspective, that what they're trying to say is that we need to hire young people and they won't be able to claim unfair dismissal. But we also need to understand that procedural fairness will remain in place. So even though we still have to follow some sort of a procedure, it is taking away some of the fears of employers to attend the CCMA. I think this is a good change, and it might result in positive fields and thinking in corporates. So if we then move on to point number 4, change to large-scale retrenchment procedures. So when we look at retrenching staff, we have 2 procedures. We have mass retrenchments, as they generally refer to, and then we have normal retrenchments. So for a mass retrenchment to take place, we have to have more than 50 employees, and we should be retrenching more than 10 employees. So that's normally when a mass retrenchment or a large-scale retrenchment will kick in. So there's a number of amendments that has been suggested with regards to the large-scale retrenchment. One of the notable, the most predominant proposal is that the commissioner of the CCMA will be granted the authority to establish rules on retrenchment facilitation rather than the minister. And when we get to a mass retrenchment, we normally refer the matter to the CCMA, and the CCMA then facilitates the retrenchment on the employer's behalf. So it is up to the CCMA to make sure the retrenchment is procedurally fair. So it takes that power away from the employer. And this change makes total sense because the commissioner is the one dealing with the matter. So giving that power to the CCMA instead of the minister just means that we will get smooth operations. A mass retrenchment normally takes up to 3 months to conclude, and it is already an extended period. So I think removing the minister from this decision making is really going to benefit employers when it comes to mass retrenchments. Very well thought out change proposal here, in my opinion. So the next proposal is to narrow the definition of unfair labor practice. So the proposal seeks to remove certain categories of disputes, restricting unfair labor practice claims to cases involving unfair suspension or disciplinary action short of a dismissal, occupational determination relating to protected disclosures, which is whistleblowing cases, a transitional period of 1 year will be provided for public service employees, allowing disputes related to promotions to be resolved under the existing legal framework with collective agreements that are being finalized. So I think it's very important to note that most of the times when we go to the CCMA, we are there because someone was dismissed. However, the CCMA has so much more cases that they are dealing with, like discrimination and issuing of warnings, unfair treatment, favoritism. The CCMA also deals with all of these matters, which of course means that the CCMA are inundated with cases. And I think the thinking behind this change is to narrow the definition to allow some leeway for the CCMA to only deal with the most important cases. I think this might help, especially employees with, fast-tracking matters at the CCMA, but it will be interesting to see how effective this change will be. So point number 6, I think this is the one with the most talking point, is increase the statutory severance pay. So most of you will be aware that when we retrench an employee at this stage, we must pay them 1 week of service, of severance pay, for each completed year of service. So if I started with the company in 2020 and I'm being retrenched this year, that leads to 5 weeks of severance pay if I started work on the 1st of June. If I only started work on the 1st of November, at this stage in June, I'll only be entitled to 4 weeks of severance pay. So this is in terms of Section 41 of the Basic Conditions of Employment Act. So the proposed amendment is to increase the severance from 1 week to 2 weeks for each completed year of service. So the big catch-22 here is the effect and the cost implications on businesses. And the way they are trying to deal with that blowback is to limit it. So if I was employed in 2020 and I'm only going to be retrenched in 2050, 5 years of my severance will be 1 week for each completed year of service. But after this amendment, if the amendment happens in 2025, 5 years will be at the 2 weeks. So this will not be applicable for any years of service before the amendment takes effect. I think this is like I said, the most disputed amendment being proposed, as the effect on businesses will be enormous. And I think there's going to be a lot of rackets when we get to the commenting stage on the severance pay section. Okay, so point number 7 is expansion of the definition of an employee. So when we look at labor legislation, the definition of an employee is very wide, very, very formulated, but they are now broadening the scope even more. And the reason behind this is to protect employees based on the changes that we have recently seen in the world of work, which of course, like mentioned in our Mentimeter, remote workers. So Schedule 11 in the Labour Relations Act will broaden the scope of employees, ensuring that a wider group of workers, including those engaged in non-traditional forms of employment, will also now enjoy freedom of association and bargaining rights. The expanded definition will also apply to Chapter 8 and to Chapter 8, 9, and 10 of the Basic Conditions of Employment Act, granting the minister the ability to set minimum employment conditions for workers in sectorial determinations. And the reason behind this, like I said, is for platform workers such as e-hailing and food delivery guys, remote workers, and all of that. So I think this is a very positive change for employees. And the effect on employers might also be a big brunt, but I think it's a good change to implement. And then the last main amendment that we will be looking at is regulation for on-call and seasonal workers. Once again, I think this is a very good amendment for employees. The effect on employers might be a bit severe, but I do think it's going to create a little bit of stability in certain markets, like seasonal working, sugarcane farming, and all of those. So the provision requires employers to confirm in writing certain particulars, including reasonable notice periods for employers to report to work and the notice period of any cancellation of work. So it is good to note that when we look at these proposed amendments, we need to find a balance between the rights of employees, the rights of employers, and where financially can we meet in the middle. And that is the reason why it is taking its time to get to the approval stage. So if we move on to our next slide, we will see that the takeaways from the points we have discussed, I think it's mostly positive. The regulation for on-calls and seasonal workers, I think it's going to have a big impact in the life of those types of employees. The test for procedural fairness, it will benefit employers and employees. So will the limitation of high-earning employees, that will have a big effect on businesses. The main concern of the changes we've discussed today will perhaps be the severance pay. But in all honesty, I think we're on a good trend to make sure the labor legislation not only protects the employees, but also protects employers. So if we look at what is next, after the minister reviewed the NEDLAC report, public consultation opportunities will arise. So Parliament will then open the amendments for comments, and businesses, market leaders, and all of those labor consultants, all of us will be able to comment on the amendments. And once the comments have been made on the amendments, it will be reviewed once again before we get to the final stage, and that is the promulgation of the legislation. So once again, there's no need for us to stress about these changes at this stage. There's a long way for us to go before we get to the implementation of these proposed amendments. I think there's a lot of hype about it. It's the first time in many years that there is proposed changes to the legislation. And I think it's just good for us to start thinking about these changes and what impact it will have on your business or your clients, so that we can make sure that we comment on them once we have the ability to do so. Okay. So if we then move forward to something a bit more relevant, it is the new draft of the Code of Good Practice on Dismissal. So we already had opportunity to comment on this code, which means we are a step further than the proposed amendments. So this is a bit more relevant. It's a bit more pressing for us to deal with. So on the 4th of May, there was an update that the public comments have been compiled into a report, and it has been sent to the minister to be reviewed. Once he reviewed and considered all the comments, the next step will be to publish the code for implementation. So also, this is not a legislative change, it's just a regulation, which means it does not have to go through the strenuous checks of legislation. But also, once again, public comment has closed on this. So the code focuses on all forms of dismissals, which include a misconduct dismissal. So you had an employee who stole your laptop, misconduct dismissal, incapacities, and dismissals based on operational requirements. So that is retrenchment. So misconduct deals with all your theft, negligence, absenteeism, AWOL, all of those types of dismissals. Your incapacities, we can divide them into two groups. Technically 3, but we'll deal with the one as such. So one is poor work performances, and the other ones are incapacities, which is your your ill health and can't say that word. Anyway, let's move on. Dismissal based on operational requirements, like I said, is your retrenchments. So these amendments aim to simplify the disciplinary procedures, especially for small to medium businesses, but they also aim to make sure that the fundamental rights of employees are seen to. So if we look at the changes, so the main point is to provide some flexibility for a small employer. So if we have an employer with only 10 staff members, they don't necessarily understand the labor law as good as a corporate company with 500 employees. So they are introducing or aiming to introduce a less formal disciplinary procedure for small employers, which then just seek to alleviate the administrative duties on these employees and to make sure that it's not a complex disciplinary or rigid hearing that needs to take place. So once again, we just need to make sure that we comply with the most important rule, which is that both sides must be given the opportunity to explain what happened, present evidence, and ask questions on the misconduct that took place. So the definition of a small employer remains vague at this stage, and hopefully we're going to get clarification once we move to the final stages of implementation of the new code. So currently, when we talk about a small employer, we think of a family-owned business, 10 employees, maybe a bit less. We're not 100% sure. But the code, as we can see now, also refers to the procedural fairness, which then links to the proposed amendments with the text for procedural fairness. And I think it's good to see how the proposed changes to legislation talk to the new code on good practice as well. So we need to bear in mind that I mentioned this earlier, when we go to the CCMA, there's two legs when we look at cases. So substantial fairness and procedural fairness. And the code once again refers to both to make sure that we emphasize the procedural fairness, but also focus on substantial fairness. Okay. So, sorry. The code focus on the procedural fairness. So what the code explains to us is that we need to inform the employee of the allegations. It must be clear, and we must do so promptly. So if we find out that there was a car accident in June, we must inform the employee now. We can't have a car accident in January and decide 6 months later, now we need to inform the employee, oh, we actually want to take disciplinary action against you. We must give the employee a fair opportunity to respond to the allegations. We must base our decisions on a fair and reasonable rationale. We cannot be biased and make assumptions. And the process must be documented. So, of course, we have the notice to attend to the employee, must be in writing. There must be some sort of minutes, whether it is a recording of the hearing or some handwritten minutes, and then the documented dismissal. So making sure that we have everything documented will also help an employer to prove that the procedure was fair. Then the main focus on substantial fairness. So the few things that is mentioned in the code is, was a rule broken or contravened? Was the rule reasonable and valid? Of course, I can't ask Helena to please go and kill someone for me. That will definitely not be a valid rule of my employment. The employee must be aware of the rule, or we can reasonably expect an employee to be aware of the rule. So once again, we know it's common cause and against the law to steal any sort of item. And therefore, when an employee steals something, even though we might not have a disciplinary code in place yet, it is ought to be known that the employee must not take things that does not belong to them. So the next thing that the employer must emphasize is the importance of the rule. So why do we have this specific rule in place? Was there actual harm or damages caused, or what was the potential? Do we always apply the rule consistently? And was dismissal the appropriate sanction in this case? So just to briefly give some examples here, if an employee arrives 5 minutes late for work, that is not a dismissible offense on first occasion. However, if we have issued corrective discipline to this employee on numerous occasions for being late 5 minutes, a dismissal might be appropriate if the employee is on a final written warning. If an employee took the company laptop and went to Cascron Stages to go and sell it, to buy some booze for the weekend, that will be a dismissible offense, because how can we trust our employee with company property if they sell it? So at the end of the day, what this means is we need to make sure that we comply with procedural fairness and substantial fairness. Any non-compliance or shortcuts can still lead to arbitration awards against the employer. Okay. Then the main point, the last main point to address is the clarity on incompatibility, poor work performance, and ill health dismissal. So once again, the code seeks to standardize the process and to provide clarity on defining the gray areas. Once again, we get to the loopholes that was mentioned in the Mentimeters, and labor law are quite full of them. So the code now defines dismissal for poor work performance. That is where training and support has failed to yield results. Cases of incompatibility is where employees struggle to fit into the workplace culture and constantly clash with team members and managers. And guys, just a word of warning on this. One of the most difficult cases at the CCMA. We all have different personalities and we experience the world different, but we have to try and find a way to work together. It is not an easy task to prove one of these cases. And then ill health or injury related incapacities is to ensure that employer followed a defined and humane process before considering termination. So when there is an ill health incapacity, we must first look at alternatives. So yes, you were employed as a truck driver, but you lost your leg. Now we need to try and see, can you not perhaps be one of the, I don't know, office workers? Can you not track the trucks and provide reports based on that? So alternatives is a very important step in all of these incapacities, even for a poor work performance. So if you are currently a team leader in a call center, is it not possible for you to be promoted to a normal sales agent instead of a team leader if you are not able to perform your duties after training and support was given? So the purpose of the new code is to reduce frivolous CCMA matters by providing clear guidelines and frameworks for employers to use, but also to uphold legal standards. In conclusion, the time to act on the code is now. So what that means for us is we need to look at our current policies and procedures in place, make sure they do align with the new code, but also to see how we can simplify. And at P&H Solutions, we can of course help you with that, but we'll get to that a little bit later. The next trend that we will be looking at is some recent case law. And I'm very excited because both my cases were actually mentioned in our Mentimeter. So the first case we'll be looking at is the Skeepers case. In this case, an employee was dismissed during a disciplinary inquiry for being under the influence of alcohol. So what happened is the employer relied solely on a breathalyzer test for the dismissal. The employer also had a zero tolerance policy, and the employer in this case failed to conduct a physical observation test. So they did not complete a checklist, and they also did not request blood tests in this matter. So the employee was a heavy-duty truck driver, and he was dismissed based on 2 failed breathalyzer tests. The test results was 0.023%, and the second test was 0.18%. It should be noted that there was no other signs of intoxication, so no smell of alcohol, no red eyes, no slurred speech. The employee was able to walk in a straight line, but he was still dismissed. So the dismissed employee stated that he consumed BioPlus and energy drinks to stay awake. He had a personal matter and had to drive through the night, so he had to stay awake. And in this case, it was common cause that BioPlus contains 10% alcohol, which therefore, of course, can lead to a positive breathalyzer test. So when the labor court, looked at this matter, it concluded that the employee was dismissed unfairly. The labor court also relied on a previous case where it found that a breathalyzer test might not be sufficient evidence, and the employee was awarded 6 months of compensation. So the takeaway from this matter is that a zero tolerance policy does not open the door for a quick and easy dismissal. Does not mean that we can dismiss employees every time they have a positive breathalyzer test. Breathalyzer tests should be viewed as corroborating evidence and not primary evidence. So once again, we have checklists that should be completed. We have witnesses, and like I mentioned, in this case, there was no other evidence to suggest that he was under the influence of alcohol. And one of my personal takeaways from this case is that we need to make sure our managers are trained on how to deal with this matter and how to gather the correct evidence. Once again, we can have a procedurally sound case, but a substantially unfair case. Very important to note that we need to be able to prove both of these. Okay, the second case we'll be looking at is a harassment case. So it is M versus the Department of Employment and Labor. Like I mentioned, it's based on sexual harassment. And what happened was Mrs. M lodged a grievance citing multiple allegations of sexual harassment by her line manager. These allegations included being molested, the manager exposing himself to her and inviting her to sexual relations, amongst other things. So she reported the incident to management, which included the provincial director, who ultimately failed to respond to the allegations. She was then moved to a different position while they were investigating the matter. But ultimately, she applied for a promotion and she was told that she was just a T-girl and sent back to work under her previous line manager. So the CCMA commissioner identified at least 6 incidents where sexual harassment took place, and once again the department did not act on them, but also did not need any evidence during the CCMA matter to disprove it. So the CCMA asked 3 questions. Was the harassment reported immediately by the victim? Of course, the answer was yes. Did the employer take the necessary steps to eliminate the alleged conduct? The answer was no. And did the employer take reasonable steps to create an environment free of sexual harassment? Which was also no. And therefore, the department was ordered to pay 6 months of compensation to Mrs. M based on their failure to comply with Section 60 of the Employment Equity Act. So Section 60 of the Employment Equity Act hold employers vicariously liable for any of their employees' actions when employers fail to take necessary procedures and stops to prevent this from happening. So our takeaway from this is that there is a common law duty on employers to create a safe working environment. And once again, today we are only looking at sexual harassment. And of course, in terms of the new Code of Good Practice on harassment, harassment is much more wider than just sexual harassment, but this case specifically focused on harassment. So we need to create a working environment free of any type of harassment. Section 60, and once again, the Code of Good Practice on preventing and eliminating harassment in the workplace should be utilized by employers to prevent awards of vicarious liability. So I'm not sure how many of you have actually looked at the Code of Good Practice, but it is very clear, very defined on what an employer should be doing. So how can we do this? By having an harassment policy with clear boundaries for all staff to adhere to, and also making sure that there's a correct reporting platform and procedure to be followed. Ensuring that a follow, report, and speedy investigation take place on all harassment matters, no matter how small they might seem. And in terms of the new code, we should have a risk assessment. So when a sexual harassment case or harassment case took place, the company needs to, just take a step back and see, what did we do wrong? How can we better ourselves? Did we do anything wrong? Yes or no? Training. Cannot emphasize that enough. Yes. So that is the case law that I wanted to look at today. And like I said, it's very interesting that both cases were mentioned in our Mentimeter. Okay, so the second part that we wanted to discuss is STRAPS, what employers should know. Okie dokes. So, labor law is not black and white. There's a lot of gray areas that we need to navigate through. And yes, we have some loopholes. Some loopholes are good, some loopholes are bad. But unfortunately, as an employer, we don't have straight answers. each case has their own merits, their own facts, and we need to navigate around them, but still be consistent in our approach. How can we help? We can have proper policies and procedures in place, have guidelines to help employers to navigate the gray areas. This can eliminate loopholes and eliminate loopholes for employees to get away with committing misconduct. I think it's important to note at this point that, you know, employees get smarter every year. I think we're all seeing that. But from an employer's perspective, by having policies and procedures, making sure our managers are trained, we can prevent employees from getting smarter on us. Updating policies regularly will help employers to stay on top of the ever-changing world of work and labor law. Based on the current trends on case law, we can get ahead of the curve and block employees from committing offenses before they can think of it. And the next step is not having trained managers in the workplace. If we can train managers and hire managers to act as a barrier between staff and the top level, managers have an obligation to discipline staff. If they don't have the skill set to do so, we must train them, as this can have a huge impact on the business. When I do a hearing, we always get to aggravation, and the manager's always, sure, but I don't feel comfortable saying that we don't trust them. But from a company's perspective, we need managers to understand that you're not thinking as yourself, but you're thinking as a representative of the company. And that's very important. We can only achieve that by training our managers. So I think these are the biggest traps. Is it's not black and white, but we have policies and procedures. We must utilize them, and we must utilize our managers to manage the workforce. Okay, dokes. So transformation, where do we go? How can we help? At P&H Solutions, we help employers navigate the ever-changing employment laws with competence. Our team can help with an audit on current disciplinary procedures to identify outdated practices and to make suggestions on how to get back in line. We can assist to train your managers and team leaders on how to conduct investigation and hearings, making sure they know what evidence to look at, what is the procedure to be followed, and also making sure they understand the severity and importance of the disciplinary procedures. We can revise your employment contracts and employee handbooks to reflect the updated disciplinary frameworks. If you don't have them in place, we can also help you to get them in place. We can also help you build a toolkit with templates and checklists that once again will assist your managers to take disciplinary action. Our specialist can help you future-proof your compliance, and we are more than willing and free to help you with a risk assessment so that we can see what is your current need and how we can help. So guys, in a nutshell, once again, it's a very brief introduction to IR and what is happening in the world of IR, what we should be looking out for, where employers fall short, and what we can do for you. But that brings me to the end of my slideshow. Once again, at P&H, we don't only focus on IR. We have so much more. So Helena, I'm going to hand over to you. If you can maybe just elaborate on what else we can help clients with.
Ooh, I'm muted there. You're getting a lot of reactions, Chantal. That's good. I'm so glad to see it's been an engaging session for everyone. Just before we end off, I just want to mention, as Chantal mentioned, some of our additional service offerings. We are expanding at P&H. We're expanding and we are building out, especially our HR department. So we not only doing HR system implementation any longer, we also have additional services that we already consulting on and doing. But we're very excited about all of these additional service offerings. So, of course, HR system implementation, that is at the heart of what we do. We love technology at P&H, so we will always advocate to use systems, especially in HR, to work smarter and to have a data-driven HR approach. So in terms of system implementation, specifically when we come to IR, we do work on systems that can help you keep track of disciplinary cases, where you can log incidents as the disciplinary case unfolds, and that you can capture all details like witness statements, documentation that was signed. You can print out notices of hearings. You can print out your warnings. So, of course, record keeping is such an integral part of managing IR in a workplace. So we have systems that are available that can really assist you with that process in terms of record keeping. And also to have a holistic view of a timeline of your IR cases. So over time, what types of cases do we have in terms of our code of conduct? What is most frequent? What happens most frequently? What are some of our typical challenges? So in terms of your reporting, as a consultant, and Chantal, you've also worked on Sage, and you've had quite a good experience with using a system then to really empower you as a consultant. We also have other service offerings like BE skills and equity consulting, not only from a system point of view, but also as a consultation standalone service with or without a system, where you can then have someone that can empower you and either teach you and equip you to do these, to fulfill these functions yourself in your company, or someone that can come in as an outsourced, partner that can drive the process along with you in your company. Like, for example, hosting your equity committee meetings. So those are some of the options that we have available. HR consulting, again, as a standalone service. So whether you just need some extra hands in your HR department, even if it's just for a season, or whether you need HR as an outsourced function, we are available to assist. We do offer all of these services at P&H. So I think then that, as Chantal mentioned, brings the presentation to a close. I just want to, we did go over time. I just want to quickly open the floor. Any questions? If you have to excuse yourself, thank you so much for attending. We really appreciate it. I see there is a question on a contact. I will reach out to you and put you in contact. Perhaps, Chantal, if you can go on to the previous, just go back to the previous slide. That QR code on the previous slide, you can actually scan it for the relevant contact information. But I will also just get your email address from the registration and just pop you a mail. So thank you for that. So yeah, thank you, everyone. We're going to stay on the call for a few more moments. Please keep an eye out for our next webinar. We have a quarterly HR webinar. We will be announcing the topic very soon. Thank you so much for participating in the session. Yes, Anamine, did you want to say something?
Yes, I just see that Lebogang is Puseletso asking for a direct contact to inquire about BE and skills consulting. Puseletso, we'll reach out to you. We've got your details, so Helena will send you a mail regarding that.
Yes, we'll do that. Thank you, everyone. And thank you, Chantal, for you. Thank you for the nice feedback in the chat. Well done to you, Chantal, for the presentation. So I'm going to upload this to our YouTube channel as well, so that we can share the link with everyone who registered.
Thank you, everybody. Bye-bye.
Thank you, guys. Thanks for listening.
Thank you. Thank you.